Good morning, everyone. Thank you so much for joining ONEgeneration's Health and Wellness Webinar Week. We're just so grateful for all of you that have been participating with us and just logging on for our webinars and just been interacting with our presenters. We're so grateful just to have you and just spending the time, just taking the time out of your day to just join us and just listen to some amazing topics. For those of you who do not know me, my name is Niambi Cooper. I am the director of ONEgeneration Senior Enrichment Center, led by our organization's president and CEO, Jenna Haas. So the layout of the webinar today will be composed of first having our presentation by Stu, and then at the end, we'll have some questions and answers, but feel free throughout the entire presentation to use our chat box to type in maybe a comment or a question. And then we also have a Q&A function at the bottom part of your screen where you're able to, if you want to ask a question anonymously, you can do that as well. And then if you don't want to do any of that, we also have a section at the bottom part of your screen that says raise your hand. And that way you're able to verbally ask a question to our presenter. And that completely is fine as well. So this presentation is being recorded, and that just simply means that we're able to replay this video, this presentation over again, and you're able to share it with your friends. So we will have this video in our newsletter, we'll have it on our website, we'll have it to where it's easily accessible for you. And if you do not already receive our newsletter, that's completely fine. You can go to onegeneration.org, and there's a section on there that says newsletter, and you can just input your email and hit submit, and then you will receive it 2 times a month. So I am super excited to introduce the Stuart Zimring from the law offices of Stuart Zimring. He is in private practice in North Hollywood, California, where he concentrates in the area of elder law, estate and life planning, special needs trust, and probate, conservatorship, and trust litigation matters. He is certified as a specialist in estate planning, probate, and trust law by the Board of Certification of the State Bar of California, and is co-author together with Christina Monogle and Melinda Hunsaker of Tax Estate and Financial Planning for the Elderly California Guide. And together with Professor Rebecca Morgan, Bradley Freong, and Craig Reeves, Fundamentals of Special Needs Trust, both published by Matthew Bender. He is a member of the Matthew Bender LexisNexis Elder Law Editorial Board and is also an adjunct professor of law at the Stetson University College of Law. He graduated from the UCLA School of Law in 1971 with a JD degree and is admitted to practice in California, the U.S. District Court, Central and Northern Districts of California, and the U.S. Supreme Court. Mr. Zimring is a fellow of both the National Academy of Elder Law Attorneys, NAELA, and the American College of Trust and Estate Counselors, ACTEC, a member of the Special Needs Alliance, and is a past president of NAELA, as well as a charter member of CAP, NAELA's Council of Advanced Practitioners. He also serves on the board of directors of a number of nonprofit organizations, including the NAELA Foundation and the Organization for the Needs of the Elderly, ONEgeneration, of which he is also currently a board chair. Today, he will be presenting on a topic called Taking Care of the Business of No Longer Being Able to Take Care of Our Business. Stuart is going to teach us the documents we need and the decisions we need to make sure our wishes are respected when we can't make those decisions ourselves. Thank you so much, Stuart. Thank you so much for being here with us today. We're super duper excited. Please feel free to take over.
Okay. Thank you, Niambi. It's a pleasure to be here, and thank you for that way too long introduction, but I appreciated it. And good morning to everyone who's joined us. I'm not sure such a serious subject is something you want to have your morning coffee over, but it's a pleasure to be here. What I want to talk about this morning is different than what most of us would understand as being traditional estate planning. When I was in law school, and learning about trusts and estates, the whole purpose of estate planning primarily was to move as much of our wealth as we could down as many generations as possible at the least expense and with as few tax consequences as possible. But that planning paradigm was created in a time when normal life expectancies were approximately for an adult Caucasian male, maybe 67 years old. And it was anticipated at the time the Social Security Act was adopted that someone would work in the workforce for 40 or 50 years. They would retire at age 65, begin to collect their pension, and they would be dead at age 68. And we see today that those kinds of numbers are totally wrong, that we are living longer, not necessarily healthier, but much longer lives. And so our approach, we don't call it estate planning, we call it life planning, because the reality today is that what you may have is a long work life and a longer post-work life that may involve retirement. It may involve very healthy, very active new retirement, second careers, and things like that. But it may also involve illness, spouse's illness, family issues. And so our approach to things is holistic. We don't sit down with a client and talk about where do you want to leave your money. We sit down with the client, with a couple, with a family, and we say, what do you want to accomplish in your life? Who do you need to take care of? And we structure a whole group of documents that we're going to be talking about today that make that work. So the plan is to take care of you during your lifetime and plan for retirement, plan for incapacity, plan to take care of children, parents, loved ones who have special needs so that they are then taken care of. And then at the back end of that, with whatever is left, planning for your kids, planning for your family, planning for after all of that. So we talk about what traditionally we would call unthinkable thoughts. And the first one is, you don't have to leave it to your kids. There is no law that says your children, your grandchildren are entitled to anything. You have worked hard for whatever wealth you have accumulated. And I tell my clients, it doesn't matter how many zeros are to the left of the decimal point. What you have when you've come into my office to talk to us is 100% of everything you've been able to acquire and save. And that should be protected for your benefit. And if at the end of the day, after you've had a great time traveling, a great time with your hobbies, a great time playing with your grandchildren, and possibly on the downside of that, taking care of an ill spouse, having caregivers, whatever is needed, there may not be anything left, but you've used it to take care of yourself. The other thing that we have to think about in terms of the unthinkable thoughts is that as we enter these later phases of our life and we become sometimes more susceptible to undue influence, more susceptible to people who want to take advantage, we have to remember that there are people out there who are willing 24 hours a day, 7 days a week to totally rip us off. There is a Nigerian prince willing to send you $10 million as long as you write him a check. So how do we plan for this? The first thing I counsel our clients is that the time to plan is today. You got to avoid, in order to avoid the crisis, you have to start planning now. It is not impossible, but it becomes very difficult, sometimes too late, when your loved one is sitting there in an ER having just suffered a stroke or in an ICU, and the healthcare professional comes to you and says, does your spouse have an advance directive, a power of attorney for healthcare? And you say, well, we were going to get around to that, but we haven't done that yet. Well, it's too late at that point. So the time to plan is now. And basically, I look at it in terms of, because none of us want to admit that we're going to get sick, that we're going to die. I mean, that's just not things we think about, or that a spouse is going to get sick. But we have to. This is the real world. And so in order to kind of ease into this process, I break down the things we need into two categories at least. The first one is, what are the documents you must have? Absolutely have to have. If you do nothing else in this world, What documents do you have to take care of the business of not being able to take care of yourself? And the first of those is an advanced healthcare directive, a power of attorney for healthcare. If you have no other document, this is the one you have to have. Why do I say that? I say that because, for better or for worse, healthcare in this country can be extremely expensive, even if you have insurance, even if you have Medicare. Remember, Medicare at best is only going to pay, not only, it is going to pay for approximately 80% of your healthcare. If you have a supplemental insurance policy, Medigap policy, that may well pick up the other 20%. But healthcare is expensive. And the other side of that is that we as a society, we like to control our own destinies. We want to make our own decisions. And when you put the two together, wanting to be self-empowered, wanting to control your own healthcare, the decisions made about your healthcare, and the costs that are involved, if you are not able to make those decisions for yourself, who's going to do it for you? The answer to that question is someone you have designated in a validly completed and executed advanced directive or power of attorney for healthcare, to whom you give the authority to make decisions if you cannot do it. That document, and there are all kinds of forms out there that you can get, your healthcare provider, your doctor, your HMO, your PPO. I'm willing to bet that if you go to the receptionist or to the nurse and say, do you have an advanced directive form? They will have it right there for you. And you can fill it out and you can sign it and get it witnessed or notarized. And that's what you need to start with. And then that's the first step. You got to have the form. And you've got to take the time to think about what decisions you would want made on your behalf if you couldn't do it. In our office, the form you would get from your doctor generally is a trifold or a 4-page document with some check boxes and a few lines for you to fill in your wishes regarding surgery, regarding medication, regarding burial instructions, regarding intubation, all kinds of everything that's involved. And that's fine. The way we do it in our office, however, is we really sit down with our clients. We counsel them on this because we think it's so important. And our documents generally run to 10 or 12 pages because we get into the weeds about, well, if this is happening to you and you've already got this condition, well, then what? And once that document is signed, as important is to make sure that the people you have designated as agent know what your wishes are. Sit down and talk to them about it. There's a wonderful book out there called Can't We Talk About Something Nicer, or something like that, by Liz Schatz. That is a illustrated book that talks about this subject. And I recommend it to you highly in discussing these things with your family. You've got to sit down with the family, with the agents you have named, and tell them, this is what I want, and go over it with them. We sit down with our kids. We try for twice a year. This pandemic has made that impossible. But when we're visiting our kids at least once a year, we sit them down and we want to go over our healthcare directive, and we get exactly that response. Oh, come on. We've been having such a nice day. Do we have to talk about this now? And the answer is absolutely yes. You need to talk about this now. And the next thing is that you can't keep this document secret. I liken this document to manure. You want to spread it around all over the place. You want to make sure your doctor has it, your dentist, your PPO, your HMO. We keep copies in our car in case we're in an accident. It's there in the glove compartment. We're registered with one of the international registries, so it's accessible online. This document is critical. The companion to that is what is called a HIPAA authorization, in which you authorize someone to have access to your medical records on your behalf. And this is a companion to the healthcare advanced directive, so that even if there isn't an emergency, you've designated someone who can call up your doctor and say, Jane's not feeling well today. Can we take a look at her medication record and see what's going on there? And they have the legal authority to do it. Otherwise, under federal and state law, no one but you can access those records. The next document that I think is part of the must-have is a durable power of attorney for asset management. You may have a trust, you may have a will, but there's a whole, and I'll talk about those in a moment, but there's a whole area of your life that isn't tied to an asset. Your Social Security, dealing with the mail, dealing with a pension. Those are not hard assets like a bank account. You need to have in place a document that authorizes someone to interact with these agencies, with the banks, with the insurance companies, with the pension administrators, with the post office, with the Internal Revenue Service. If you're not able to do it, to act on your behalf. An agent under a durable power of attorney is someone who, in effect, is a shadow of you. They stand in your shoes, either simultaneously with you or only in the event you become incapacitated, to take over again in managing your daily life, signing the checks, paying the bills, taking care of the gardener and the pool guy. This document, again, there are forms out there. Will tell you right now, there's what is called the statutory form durable power of attorney in California. I don't like that document. In terms of dealing holistically with the kind of decisions we want our clients to be able to have someone make on their behalf, I think it's insufficient. Is it better than nothing? Absolutely. But again, our documents, that's a one-page document. Our documents generally run to 6, 7 pages in going into the details of taking care of someone. So the last part of the must-have documents is the nomination of a conservator. A conservator is someone who is appointed by a court. You probably, over the last 2 days, we've all been hearing about the Britney Spears conservatorship case. A conservator is someone who is appointed to take care of someone who does not have the documents I've just been talking about in place. And therefore, there's no one who has authority to take care of them. And a court has determined that you do not have the capacity to take care of yourself. So this person is appointed. In California, that person is called a conservator. In other states, it's called a guardian and a guardianship proceeding. This person is appointed by a judge, and that person is given the authority to take care of those things that you haven't already taken care of by creating advance directives, powers of attorney, wills, or trusts. The process is expensive. It is invasive. It takes time. Right now, if I were to file for a conservatorship in Los Angeles County for someone who needed it, it would take probably 3 months for there to be a hearing on that petition. And who's going to take care of you in the meantime? The point here is, if for some reason you need a conservator, then who is that person going to be? So the last document that I suggest you have in connection with the must-have documents is you nominate the person you want to take control if you're not able to. It comes back to my belief that we should have as much control over our lives as we possibly can. It's empowerment, it's self-determination, and I think it's the right thing to do. Nomination of conservator, that's the easiest document in this group. You can take a piece of blank paper or line paper, piece of notebook paper, and write on it, I hereby nominate my wife, Jane Doe, as my conservator of person and estate. You date it, you sign it. It doesn't have to be notarized. And believe it or not, under the law, the judge hearing their petition to have a conservator appointed for you is going to have to honor that document unless there's a good reason not to. So those are the core documents. You have those, you're going to be okay, in lowercase okay, no capital letters. But then life isn't that simple. We all have assets. Many of us have our own homes. We've got people we love and we want to take care of and we want to remember. So the next step is, what are the documents you should have? And now we get into some of the more traditional areas of life planning and estate planning. I think you ought to have a trust. you certainly should have a will. In California, the primary estate planning, life planning document is what everybody calls a living trust. Technically, it's called a revocable inter vivos trust, but we're going to call it a living trust. And it accomplishes one primary thing, two primary things in California. One, if it's properly drafted and properly set up and funded, and I'll talk about that in a moment, it becomes a way to avoid probate proceedings. You're never going to see the inside of a courtroom. Your heirs are never going to see the inside of a courtroom, which makes it more efficient and more economical. And two, it puts in place, along with the advance directive and the power of attorney for healthcare, a solar system of documents, if you will, that give one person, various people, they can be the same person, the overall ability to assist you in the event you're not able to do that. Take care of yourself. So a trust is an entity. Think of it as a business. And when you create a trust, the business is going to own all of your assets. Right now, let's say you own a house. And when you set up a trust, title to that house, which currently stands in your name, is going to be transferred into the trust. So the trustee of the trust, the CEO of this business of you, is now going to own the house. The trust is going to set out in detail what the trustee, the CEO, is to do with the assets. Now, during your lifetime, you're going to be the CEO. So for all intents and purposes, the trust is almost transparent. Think of a jellyfish. You can look right through it. But if you become incapacitated and you can't take care of the business of you, then whoever you've designated, again, back to the concept of self-empowerment, self-determination, that person is going to become the new CEO. And that person is now going to control and run the business. Now, in addition to the house, your bank accounts, your brokerage accounts, your other assets, cars, vacation home, whatever it is, are going to be assets of this business. So this new CEO who's helping you now is going to have the ability to pay bills on your behalf, control the investments, do whatever is necessary. Now, the difference between a life planning trust and a traditional estate planning trust is that in our trusts, again, we focus on taking care of you both in health and in illness. So our trusts focus on what is that new CEO supposed to do for you if you are incapacitated. And we have a whole section in our documents called personal care provisions. Our document says, hey, if you are incapacitated and physically incapacitated, and it becomes necessary or convenient to put in wheelchair ramps in your house, to expand some doorways, to be able to accommodate a walker or a wheelchair, the CEO of that business is specifically empowered and instructed to use your assets to do that, to give you the best quality of life you possibly can, and to spend whatever is necessary to do that. Now, retirement assets, and I'm not going to get into too much detail on this, but retirement assets, your IRA, your 401k, your Roth IRA, your 403b, your corporate pension, they're not assets of the trust for various legal reasons. So at this point, the trustee, the CEO of the business here, and your agent under your durable power of attorney for asset management are going to work together so that your minimum annual distributions from your IRA or your monthly pension checks all come together to take care of you. And then at the end of the day, when you're gone, then the business, the trust business says, well, here's what happens. And it comes back to what I was saying before, whatever's left then goes to whoever your heirs are, whomever you selected, charities, friends, whatever. So the difference between a will and a trust is very simple. What is the formal name of a will? We all know this. Last will and testament. Okay. A will speaks at death. A will is an absolute meaningless piece of paper until you die. So during your lifetime, there is no ability in that document to control what's going on. You could rely on a durable power of attorney for asset management. And if you didn't own a house or property or significant assets, that may be just fine. We have many clients who say, I don't need a trust. I don't own any property. I just get my Social Security and my pension. And that's fine. If you own assets in California, especially if you own a home, you really probably need to talk to someone about having a trust. And I strongly, strongly urge you to avoid the businesses that are out there, the ads you see, living trust, $200. Those aren't lawyers. And I can tell you right now, very seriously, we make more money fixing those errors than if we had represented you in the first place, creating the document the way it should have been created. So you want to have the durable power of attorney. If appropriate, you want to have a trust. If you don't care where your assets are going when you die, then let the court deal with it in a probate proceeding. But if you care, then you need to have a will, you need to have a trust. The other thing you really should have, and it usually is part of a trust if you're doing that, is a comprehensive list of your assets, your passwords, your logins. They need to be in writing. The safest password vault you can possibly have is a spiral bound notebook in which, as you change your passwords, you can cross out one, write in another. Yes, it's very nice to have a password, a digital password vault that you access online. But if you forget the password to get into that, you're in trouble. And if you haven't given that information to your agent or to your trustee, you're in trouble. So having it down all in writing is a really good idea. You need to make sure that the beneficiary designations on your IRAs, on your life insurance policies, on your retirement accounts, on your annuities are current and are what you want them to be. Remember that I said that those kinds of assets, IRAs, 401ks, pensions, annuities, life insurance policies, are not part of a trust. They're driven, they are controlled by their beneficiary designations. And one of the things we do, one of the homework assignments we give all of our clients when they come in is we say, okay, you got to contact the administrator of your pension plan, the custodian of your IRA, the life insurance company, get copies of your current beneficiary designations. Take a look at it. Is that what you want to do? Have things changed? Any number of times in our over the years, and I've been doing this now for close to 50 years, I have had a client come back and say, oh my God, my ex-husband is still the beneficiary on my life insurance and on my IRA. And I've been married to my new husband for 20 years. Well, if something happened, that beneficiary designation would have controlled. So it's important to check these things out. It's all part of when we meet with our clients, it's all part of a physical, we give their estate plan and their life as we assess what do they need to do, what should they be doing. And we continue to meet with our clients. Our recommendation to our clients is that once every 5 years, let's touch base. And clients will call me and say, hey, you told me to call 5 years. It's been 5 years. Do I need to change anything? I'll bring up their documents on my screen. I'll ask a couple of questions and I'll say, fine, you're healthy legally. Talk to you again in 5 years. Okay. I want to jump into the weeds a little bit on some of the documents we've been talking about. The first one is people talk about advanced directives, powers of attorney for healthcare, living wills. So there is a difference between these documents and how they function. First of all, living wills do not exist in California. They still exist in other states. And a lot of what we're talking about today, just as background, is state specific. So I'm talking about California law. If I were a New York lawyer and I were giving a lecture like this in New York, I'd be talking about several different things because, for example, trusts aren't as big a deal in New York as they are in California. So it's very state specific. And we're talking today about California. In the area of healthcare directives, An advance directive is a written document, signed, notarized, that expresses your wishes as to what you want done from a healthcare standpoint if you are not able to do it. It is a guide to your healthcare practitioner and to your loved ones, but it in and of itself does not give anyone the authority to make decisions for you. That's a power of attorney for healthcare. And on the one hand, a power of attorney for healthcare can be a very simple one-page document. I, Stuart Zimring, hereby appoint my wife, Carol Zimring, as my agent for my making healthcare decision-making, period, dated, signed, witnessed, notarized, done. She now has full authority under the law to make any healthcare decision for me. And the definition of the word healthcare decision is extremely broad in California. But I haven't given her any guidance. So we combine the durable power of attorney designation with the advance directive, and that's that 12-page document I was talking about, to give her guidance as to what I want done in any given circumstance. And in addition to her, and this is another thing, both in terms of agents under durable powers of attorney for healthcare, durable powers of attorney for asset management, trusts, wills, you always want to have backup, what I call a deep bench. You want to appoint at least 2 more people to step up if the person ahead of them isn't available. Talked about this before. HIPAA authorization, again, and it's a separate document. My wife has the authority to access my health records, whether or not I'm able to do it or not. So that's why there are 2 separate documents. So this is really pragmatic. She can fill my prescriptions, refill my prescriptions. I can refill her prescriptions. I can call her doctor and say, hey, she's in bed, she's running a fever. And that healthcare professional can talk to me about her. And it isn't a question of needing to make decisions. It's simply a question of gathering information and sharing information. As I said before, there are assets that aren't part of a trust. And I'm going to just kind of put wills to the side, because in my world where we're talking about wanting to take control of our lives and ensure that what we want done with ourselves, with our bodies, with our wealth, for our loved ones during our lifetimes is more important, wills don't really play into that, because the will is only going to speak at the moment I die. So we focus on the documents that are going to be useful during my lifetime. And so there we have the durable power of attorney for asset management. I want to give someone the authority to sign my tax return if I'm not able to do it, to deal with the bank, to deal with my brokerage accounts, to deal with my passwords, to deal with my social media accounts, to deal with the 529 plan I've set up for my grandchildren. That's where the durable power of attorney for asset management comes in. And it links with the other documents, with the healthcare power, with the trust. Simple example. Let's say I'm incapacitated and it's going to be appropriate for me to either have caregivers or to move into some assisted living facility, some memory care unit, whatever. Okay, that is a healthcare decision. My agent under my power of attorney for healthcare is the one who is going to decide which facility I'm going to move into. If I'm going to stay at home, who are the caregivers going to be who are going to be hired to take care of me? That's a decision made by the agent under my healthcare power of attorney. But that person under that document doesn't have the checkbook. The person who has the checkbook is the trustee under the trust, or possibly the agent under my durable power of attorney for asset management, who would be making withdrawals from my retirement accounts. So our documents integrate with each other, and the trust says, and the durable power of attorney for asset management says, if I need to be in a facility, if I need caregivers, and the agent under my power of attorney for healthcare comes to you, Mr. Trustee or Mr. Agent, and says, I'm hiring so-and-so, or I'm putting dad into the Happy Acres memory care unit, and you have to start paying the bill, the person who has the checkbook under the documents is instructed to say, absolutely, how much do you need? It's not even a conversation. So that's how they all integrate together. And that's why we have these multiple documents. All right, we've already talked about the difference between wills and trusts. I want to focus on the last bullet point here. Which do I need? And I'm seeing we've got about 7-8 more minutes before we're going to open it up for questions. So if you have, the numbers in California have been going up, but right now, if you don't own property that has a value of more than $162,000, don't ask me where that number came from. If you live in an apartment or living off of Social Security and you don't have significant assets, you may not need a trust. We have lots of clients who have no need to have a trust, in which case a will is fine. You may have assets that are more than $162,000, and that's the break point as to when you can avoid going to court and when you have to go to court for probate. But I have some clients who have no spouse, they have no children, they have no siblings. They want to leave all their assets to charity. And they say, hey, why do I need a trust? And I will say, from an estate planning standpoint, the answer is you probably don't, because if you're leaving it all to charity, why should you spend the additional funds it takes to create a trust, which is going to save them some money in avoiding probate, when they're fully capable of paying the cost of the probate? On the other hand, if you only have a will, then you absolutely need to have the durable power of attorney for asset management. You need to have the advance directive. But in any other case where you have children, where you have friends to whom you want to leave things and you don't want them to bear the expense or the inconvenience of probate, then a trust really, really makes the most sense. Oops. Okay, back up here. Okay. Another kind of trust that we're seeing a lot more of these days is what is called a special needs trust or supplemental needs trust. And this is an additional part of the holistic taking care of things while we're still alive puzzle that I've been talking about. If you have a child, a grandchild, a sibling, a spouse who has some physical, mental, emotional disability, who may be receiving public benefits such as Medi-Cal or in-home supportive services or SSI, supplemental security income, you don't want to put them in a position of having their benefits jeopardized by leaving them something as an inheritance. The rules, both federal and state, are rather severe. Basically, if a person is receiving either Medi-Cal or supplemental security income, SSI, and they have more than $2,000 to their name, their benefits are going to be adversely affected. They're going to lose their SSI, which may trigger their losing Medi-Cal. So we have to be careful. You have to think through, I want to leave my grandson a gift. I want to leave him $10,000, just something so to let him know that grandpa really cared about him. But if my grandson is on the autism spectrum and he's receiving Medi-Cal and he's receiving SSI or any other governmental benefits, and I give him a check for $10,000, I have hurt him. I have not helped him. So in that arena, we want to create these other documents, and I'm not going to spend too much time going into the details, but a special needs trust or a supplemental needs trust, when properly drafted, is going to gives you the ability to leave a gift for a person with a disability in a way that will not have an adverse effect on their ability to obtain or retain their public benefits, whether it's Medi-Cal or supplemental security income or food stamps, CalFresh, any of the other public benefit programs out there. This can be part of your existing trust to take effect when you die. It can be in existence right now. And I would caution you, I urge you, if you have a situation such as this, you have a child who has a disability, and there are grandparents out there or aunts and uncles who want to leave something to that child or want to help that child in some way, you need to talk to them about modifying their estate plans. This is now multi-generational planning, modifying their estate plans so that they don't make the mistake of leaving that person a gift that is going to hurt them. Now, last thing I want to talk about this morning before we open it up is retirement income. These days, there are multiple paths in which we are receiving retirement income. All of these are not hard assets in the sense that they are a bank account that we can simply write a check on. They are different. Social Security is not merely, Social Security is a flow of cash. You can't cash out your Social Security account if you want to. You're just going to continue to get your monthly check. Pensions, government and corporate pensions work about the same way. Unless you have contributed into that plan yourself, there's nothing there for you to cash out. So these are not assets, as I said before, that are going to be part of a trust. They're going to be something that you want to make sure your agent under your durable power of attorney for asset management have the ability to control. We've seen a huge change in how retirement accounts, IRAs, 401ks, 403bs are handled under the new Secure Act that went into effect. You need to talk to your tax advisor. You need to talk to your financial advisor about what effect those changes in the law may have on what will happen to those accounts if there are monies left in them when you die. Annuities are the same thing. As I said before, I strongly urge you, one of the real takeaways I hope you have today is the next thing you do is contact the insurance company, contact the pension administrator, contact the IRA custodian, and find out, verify who your designated beneficiaries are, and if necessary, get the forms to change those. Insurance. I'm not a big fan of life insurance. It is a tool that we have that helps us at a point in our lives as we move through life. When you have young kids, when you have a mortgage, when you have college tuition you need to deal with, yes, having life insurance in place to take care of that is very important. But don't let inertia set in the sense of, well, I've always had this life insurance policy. Why should I get rid of this life insurance policy? Because you don't need it anymore. If it has a cash surrender value, take the cash and do something else with it. At the same time as you're doing this self-assessment as to what do I need to do in terms of documents, what do I need to do in terms of these other kinds of assets that are out there, like life insurance. It's nice to say, I've got this $100,000 life insurance policy. Do you need it? You may need a small policy to help with burial expenses. You may have a reason for having a life insurance policy. All I'm asking is stop and take the time to ask yourself that question. Long-term care insurance is a different subject completely. The long-term care insurance industry has changed radically over the years. If you want to look at long-term care insurance, nursing home insurance, which is now much more than just nursing home insurance, yes, it's worth a look. For those of us of a certain age, I think it's priced out of the market. But if you are, say, 40s or 50s, there are a whole new range of insurance products, combinations of life insurance and long-term care insurance that I think are certainly worth looking at. Absolutely. If you have an existing long-term care insurance policy, I would keep that policy. The costs of long-term care continue to go up, and as long as the annual premiums are not prohibitive, it pays to keep that policy in place, in my opinion. Okay, I had promised Niambi that we were going to break for questions. So taxes are out there. They are one of the few guaranteed benefits we have. I don't know, benefit, but it's one of those things along with death. You ain't going to get away from it. For most of us, we don't have to worry about estate and gift taxes. There is no inheritance tax in California. And the estate tax right now is only going to impact you if your estate is worth more than $11.5 million. I don't know about you, but I don't worry about the estate tax right now. Things could change. Congress is thinking about making all kinds of changes, but I would say from my world, in terms of the kind of planning we do for our clients, we are not concerned about the estate tax. We're concerned about taking care of you. And as I put it, the estate tax tail does not wag the holistic taking care of you dog. With that, there are other things we could have talked about. I'm happy to talk to any of you who want to consult with us on all kinds of issues we didn't talk about: Medi-Cal, subsidized housing, VA benefits. This is a area of the law that is changing radically. We're beginning to see some really good improvement, especially in the area of expanding VA benefits, although it is a totally overloaded system at the moment. As I said at the beginning, be careful. Be careful. There are people out there who want to take advantage of you. And I believe this slide deck is going to be available to people. I can certainly make it available. But if you feel that you have been the subject to financial elder abuse, call the police, call the city attorney, call Adult Protective Services. There are organizations out there, legal aid organizations like BetSedec, like Neighborhood Legal Services, who can help you. If you are the victim of spousal abuse, there is a wonderful organization called the Harriet Buhai Center that is there to assist you in that regard. Other resources that are out there are here. ONEgeneration has phenomenal resources available. Consult your religious institution. And as Niambi pointed out, I'm very involved in the National Academy of Elder Law Attorneys. And if you have loved ones or family members who need assistance in other states, you can go to their site and find the name of an elder law attorney who does what I do in their geographical area for their assistance. It's been a pleasure. I'm going to stop sharing the screen, come back in here, and happy to answer any questions that I can for anyone who has a question.
Thank you so much, Stu, for that amazing presentation. We do have a question. Can you designate more than one person on a HIPAA authorization?
Absolutely. You can have, I'm really glad you asked that question. It is perfectly legal and possible to have more than, you can have co-agents, you can have co-trustees, you can have co-persons designated on a HIPAA authorization. On a HIPAA authorization, I think it's fine. You can name multiple people, all of whom have access. When it comes to co-agents under a power of attorney, whether it's a healthcare power or a durable power of attorney for asset management, you can do it. I'm not a big fan of committees. So if you want to name co-agents in that context, you want to be able to tell, you want to make sure your attorney understands that you want either of them to be able to function independent of the other. You don't want to have them having to make decisions jointly. This is especially critical, in my opinion, in the healthcare decision-making world. You do not want to create the situation where you're laying there in bed and you have named all of your kids as co-agents to make healthcare decisions, and they're standing at the foot of the bed and they can't agree. The healthcare professional is going to throw up her hands and say, this document is now worthless. You can't agree. You're going to have to go to court and get instructions, or you're going to have to come to some decision, but I'm not going to stand here while your mother is suffering while you guys can't figure out what you want to do. And so one agent at a time under those documents, co-access to HIPAA, absolutely no problem at all. And what we do where we have, just as an aside, in my document, for example, my healthcare directive, I have appointed my wife as my primary agent, and then my children, we have 4 kids, as successor agents. And to avoid issues among them, if they're going to be the agents, our document specifically says that if one of the children is acting as agent, he or she must consult with his or her siblings before making a decision. It's built right into the document, and actually it's in bold print. There's still only one decision maker, but that person is mandated to discuss it with his or her siblings. I hope I answered your question. Anything else? Oh, I can't believe I answered everybody's questions.